let's talk about power of attorney errors. This is a subject that I could go on and on about, and I'm not going to. I'm just going to tell you a few of the key problems that happen with powers of attorney. The first problem is not having a power of attorney drafted, period. Okay, if you don't have a power of attorney, you lose capacity, you're going to be under a guardianship or conservatorship. So let's set that aside. What is another power of attorney error? A key problem is not having that document drafted in the state where you reside. A power of attorney document is intended to give somebody else authority to act on your behalf for financial matters or for healthcare matters. So that power of attorney document needs to be accepted, for example, by your bank. And if your bank is in a certain state and they're used to seeing powers of attorney drafted in such a way to comply with the laws of that state, if you come and bring in an out-of-state power of attorney document, the bank is likely to look at that and say, we're not going to accept that. That doesn't look right. Technically, the bank should accept a power of attorney document that's valid in a different state. But practically speaking, they may not, so it's problematic. So you want your power of attorney document to be drafted in the state where you reside. Another key problem, I've been saying power of attorney, but what I'm really talking about is durable power of attorney. Durable has to be in the document. Durable says that if I lose capacity, if I can't take care of my affairs, and somebody else I've appointed is going to step in, they have the legal authority to do so. How is it that they have the legal authority to do so? They have that authority because my document, my durable power of attorney document, says it's durable. Without that term durable, if I lose capacity and my document is not a durable power of attorney, the document is no good. It has to say durable. Remember, if that document is no good, then I'm subject to a court-ordered guardianship and conservatorship, which is the last thing you want to have happen. So make sure your document is durable. The next big problems with powers of attorney are the grants of authority that are in them or that are not in them. In Washington State, we can draft a durable power of attorney such that you grant all the authority you can imagine to somebody except for the power to do a new will. But you can include a power to change beneficiary designations on your 401k or IRA, to change bank account ownership from joint tenants, to change transfer on death provisions on a bank account or a life insurance policy, to execute a transfer on death deed, to give away money, and not just for the annual tax exclusion amount, but give away, for example, all of somebody's money because you're doing it as a part of a Medicaid plan to qualify for Medicaid and to avoid estate recovery. These are big grants of authority, and many attorneys will advise clients, don't do that. They can change your whole estate plan. It's really important that you speak with your attorney about what grants of authority are appropriate for you. At ELG Estate Planning, we do Medicaid planning. We protect and preserve assets, especially in the face of long-term care costs. So we will have the discussion with our clients about why it might be a really good idea to include all those broad grants of authority. Everybody's situation is different. It's important that you understand what happens if you do have such broad grants of authority or if you don't. When clients come to us and somebody else has drafted their durable powers of attorney and they're coming to us because they want to protect assets against long-term care costs, and their power of attorney doesn't have this authority and now they've lost capacity, our hands are often tied to protect any assets for them against long-term care costs. maybe they weren't thinking about the future and that they might want to protect assets. It's hard to know, but what is important for you to understand is to talk to your attorney. Ask them about your power of attorney and the grants of authority, and also ask them, what happens in the future if I lose capacity? What happens if I need to go to an assisted living, memory care, or skilled nursing facility? Is this power of attorney going to be adequate to help my family plan a Medicaid plan to protect my assets? So we have a lot of videos on Medicaid planning and such, but I just want you to be aware of, it's incumbent on you, it's really important for you as the client to understand what do your legal documents mean and why might a grant of authority and a power of attorney be a really good idea or not such a good idea.